I call this meeting to order and would like to welcome everyone to the 33rd meeting of the Standing Committee on Access to Information Privacy and Ethics, pursuant to Standing Order 1083H and the motion adopted by the committee on Tuesday, July 26, 2022. The committee is meeting to study device investigation tools used by the Royal Canadian Mounted Police. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23rd, 2022. Today we have three witnesses in this panel. We are pleased to have today Ronald Diebert, Professor of Political Science and Director, Citizen Lab, Munk School of Global Affairs and Public Policy, University of Toronto. We also have Brenda McPhail, Director, Privacy, Technology and Surveillance Program with the Canadian Civil Liberties Association. We are expecting Michelle Juno Katsuya, researcher on national security and intelligence, and my understanding is that we are in the midst of navigating some technical issues with that witness. So we will proceed with opening statements from the other two, and we certainly hope to have our third witness on with time for him to deliver his opening statement. So with that, I will begin and ask for Professor Diebert to begin with up to 5 minutes. You have the floor.
Thank you, Mr. Chairman. I am Ron Diebert, Professor of Political Science and the founder and director of the Citizen Lab at the University of Toronto's Munk School. Since 2001, the Citizen Lab has researched information security issues, and one of the principal areas of our research has been the mercenary spyware industry, in which private actors sell hacking services to governments. We are widely recognized as one of the world's leading authorities on this topic. I and my staff have testified or provided briefings numerous times to the US White House, the Department of State, Congress, the European Parliament, and other governments on this topic. I'm very pleased to be speaking about it for the first time before a Canadian House of Commons committee. Today, I want to highlight several themes that arise from this research. First, the mercenary spyware industry is very poorly regulated and proliferating quickly. The industry lacks public accountability and transparency. It thrives in the shadows of the clandestine world and is spreading fast without proper controls. Second, we have documented extensive harms and abuses in just about every jurisdiction in which spyware is deployed. Governments routinely use spyware to hack civil society, political opposition, journalists, lawyers, activists, family members, and other innocent victims, both domestically and abroad, including victims living here in Canada. Third, the mercenary spyware industry is not only a threat to civil society and human rights, it is also a threat to national security. We've observed heads of state and senior government officials who've had their phones hacked with spyware. Not long ago, we notified UK authorities about a device we observed being hacked in 10 Downing Street, residence of the Prime Minister. In short, our 10 plus years of research shows the spyware industry is one of the most serious threats to civil society, human rights, and democracy today. The recent revelation about the RCMP using spyware raises serious concerns. First, spyware is not like a traditional wiretap. It is more like a wiretap on steroids. Advanced spyware is to surveillance as nuclear technology is to weapons. It represents a quantum leap forward in sophistication and power. The latest versions provide silent and unfettered access to a target's entire pattern of life. Despite these nuclear-level capabilities, it is remarkable that there has been zero public debate in Canada prior to the RCMP's recent revelation. Second, the threshold for use, oversight, transparency, and public accountability must be much higher than for a traditional wiretap. This is especially critical because the RCMP and other security agencies in Canada have a well-documented history of abuses and discriminatory practices. Third, we need transparency with respect to where Canadian agencies are procuring this technology. Yesterday, the Minister of Public Safety would not acknowledge to this committee from which vendor or vendors, the Canadian government purchased spyware. There is absolutely no reason why that should not be disclosed, and plenty of good reasons that it should. Our procurement should be transparent and include rules for vendors so we do not purchase from and help enrich firms that sell to governments abroad that threaten Canada's values and security. Fourth, there are serious public safety concerns around the very existence of this technology. Mercenary spyware is founded on the discovery of software flaws that the software vendors themselves are unaware of or have not patched. The very use of this technology fuels a market that exploits collective insecurity on all of our devices. Canada's overall process, such as it is, to weigh the equities around these trade-offs is poor and opaque. Fifth, the RCMP's quiet revelation sets a very bad example for the rest of the world. The Canadian government purports to protect human rights and stand for rule of law and democracy around the world. In adopting this technology without public debate and proper limits, we are essentially signaling to the world that we do not really care about these principles. I close my remarks with 7 specific recommendations. First, hold public hearings on the threats of the mercenary spyware industry, especially since Canadians have been victims. Second, if Canadian agencies are going to use spyware, public consultation should be held and the government should develop a legal framework that is compliant with the Charter and international human rights law. Third, Canada should develop strong export controls for the Canadian surveillance industry. Currently, there are none. Fourth, Canada should penalize spyware firms that are known to facilitate human rights abuses abroad, modeled after those in the United States. Fifth, Canada should issue clear and forceful statements at the highest levels, for example, from the Prime Minister, Minister of Public Safety, and Minister of Foreign Affairs, that we take this threat seriously. Six,
You're significantly over time. Please, quickly, please, on the last 2.
6, Canada should impose a lifetime ban for those who have worked in our security agencies from ever working with mercenary spyware firms. And lastly, Canada should make public which firms they are contracting with and develop procurement guidelines for Canadian agencies so they never contract with firms that are connected to human rights abuses abroad. Thank you, Mr. Chairman.
All right.
Apologies for going over.
No, that's all right. Now, next, I will ask Ms. McPhail to begin with your opening statements.
Thank you for inviting the Canadian Civil Liberties Association to appear before you today. I'm grateful to the committee for commencing this study of the RCMP use of on-device investigative technology because it's an issue of national concern that is also a symptom of a larger problem of inadequate oversight and accountability when police acquire and use advanced surveillance technology. The revelations about ODIT are just the latest in a series of similar media-led reveals regarding invasive techniques from social media monitoring to cell site simulators to the illegal Clearview AI facial recognition. This isn't a one-off problem, it's a pattern pointing to a crisis of accountability. Operational secrecy is a legitimate need in specific investigations. Secrecy around policies that apply to categories of dangerous surveillance technologies is not legitimate in a democracy. We must not allow law enforcement bodies to conflate one with the other to avoid accountability. Why are these technologies dangerous from a civil society perspective? This committee is aware of the basic risks to privacy rights, so I'll focus on 3 other reasons. First, our government agencies are encouraging an industry known for prioritizing profits over human rights and feeding the worst impulses of authoritarian governments. I work with a network of global civil liberties organizations where many of my colleagues see Canada as a role model on issues of law enforcement and due process. This kind of revelation diminishes our international reputation, not just at the level of governments, but on the ground. Second, using these tools encourages law enforcement, as Professor Diebert noted, to exploit vulnerabilities in the technologies we all depend on, rather than help get them fixed. We've known for some time that the CSE has dueling accountabilities in relation to their active cyber mandate and their responsibility to protect our cyber infrastructure. Now we know the RCMP have a similar conflict. This is making us all a bit less safe daily in the name of public safety. And finally, there's a question of due process. Your witnesses yesterday noted that an agreement detailing the ways the technology has to be protected is a condition of its use. What impact does that agreement have on court disclosures? Are cases ever not taken forward because to do so would reveal details of the technology? In other words, how does operational secrecy compromise the pursuit of justice? Those are some of the problems. What are the potential solutions? First of all, I do believe we need a moratorium. This study is just the beginning of an important public conversation we need to have in Canada. It's true, if it's true, that this technology is a last resort option, it can't be that much of a risk to public safety to pause its use briefly, certainly not when weighed against the privacy and due process rights at stake, as well as the social and diplomatic impacts of the Canadian government condoning the sale and use of spyware. Then we need to get back to basics. And the basic question isn't, how do we make sure the RCMP or any other body uses these tools lawfully? Rather, it must be, is the use of such tools necessary, proportionate, and in keeping with Canadian values? It probably won't surprise you that I think it is not. I think, like Europe and the United States, we should include the potential for a ban on state purchase of this kind of spyware technology in those conversations we need to have. But if it is democratically debated and determined that it is fit for a narrow purpose, the second question we then need to turn to is how to make the concept of lawful use more meaningful by updating our laws to appropriately govern the decisions to purchase and use these technologies and to provide transparency and accountability sufficient to engender public trust. For those laws to be good enough, we need stringent, effectively enforced import and export controls and limits. We need a system where decisions about using controversial, potentially rights-infringing technologies can no longer happen behind the scenes. For that, we need not just mandatory privacy impact assessments, but should consider the creation of a truly independent advisory body working with appropriate transparency specifically to evaluate and set national standards for the procurement and use of surveillance technologies, as they have done in New York State. We would also need public reporting obligations on the use of audits. The annual report on the use of electronic surveillance, repeatedly mentioned as an accountability measure, is insufficient. The tools used for this surveillance matter. That's why we're having this conversation. Yet that report simply gives statistics for any audio or visual surveillance, which leads to a final point. Only one warrant application of the 331 in that report was refused between 2016 and 2020. That suggests that we need a public interest amicus present at those applications to provide a counterpoint to police positions. There are more problems and more solutions, but my 5 minutes up, so I look forward to your questions.
All right, thank you. And although I can't see him on the screen, let me ask: do we have no? Are we in touch with him, though? We're in contact with him. Okay. Well, we may not get an opening statement from witness Michelle Junot Katsuya. We will have to begin with our questions. So with that, I ask Mr. Bazan to lead us off.
Thank you, Mr. Chair, and I want to thank our witnesses for joining us today and for their expertise on this. To both Professor Dibert and Ms. McPhail, has your organizations studied in depth which vendors are potentially in use here in Canada that sell spyware?
Which one should go first?
Your
Brendan?
choice. Professor, why don't you lead off? You got your mic
Sure.
on.
So we have documented extensively spyware vendors around the world, and unfortunately, we lack transparency on this the answer to this question here in Canada because there is no public information available to any of us as to which vendors the government is procuring from, which, as I mentioned in my comments, is very problematic. As you heard yesterday, when asked pointedly about this question, the Minister of Public Safety declined to answer, and I don't think that's a legitimate answer.
Ms. McPhail?
We have not done that research.
Okay. Ms. McPhail, you mentioned in your opening comments the concern that maybe the RCMP hasn't proceeded in the prosecution of certain criminal cases or national security threats because they would have to disclose that they used audit. Do you have any proof of that they would rather not prosecute to protect the technology?
There is a case in the past called Project Clemenza, where it was revealed that a number of prosecutions were dropped rather than reveal the fact that a key to access encrypted communications had been obtained by law enforcement. That's the only example I know of. But the mention of a specific agreement, which your witnesses yesterday described as constraining the use of the tools and what could be said about them in public, does give rise to concern about appropriate disclosures in court.
Do you believe that the failure of the RCMP to go forward with that prosecution was because they didn't have a proper warrant that they used to collect that information on those individuals, or that they did so under other mechanisms such as national security?
Anecdotally, I'm led to understand that it was done to protect the use of the tool, not because correct warrants weren't acquired.
Okay. You know, often when I've traveled abroad, I've been briefed by Department of Foreign Affairs officials or Department of National Defense officials about the potential of having my cell phone hacked, that the camera and the microphone could be turned on at any time. Do you believe that we need to take extra precautions here in Canada as parliamentarians, as people that work on the Hill, that our government-issued phones are potentially hacked by not just foreign actors, but others domestically as well? And I'll give that to both Ms. McPhail and Professor Dielbert.
I do think it's a concern, but I also think Professor Diebert is best prepared to answer this question.
Okay, Professor?
Yes, I think it's a major concern. The fact of the matter is that you have devices that are highly invasive and tend to be poorly secured overall, given the nature of the digital ecosystem that we live in, next to an industry, as I've described, that spends millions of dollars to identify software flaws without disclosing them to the vendors in order to provide this hacking as a service. We've also documented numerous cases of government officials and even heads of state having their devices hacked with the most advanced spyware. As I mentioned in my open remarks, we observed a hacked device in 10 Downing Street, the residence of the Prime Minister, and reported that to UK authorities. So really, no one is immune from the most advanced types of spyware, and there are no international regulations, and it's proliferating widely to governments around the world.
Professor, in the research that you've done, do you believe that, although it would be unethical, but do you believe that employers, including the Government of Canada, would be able to get clearance to use spyware as a way to monitor employees and people of interest that have government-issued or company-issued devices? Would there be a loophole where they could get around having to apply for warrants because it would be property owned by the employer?
Well, that's an interesting question. I know there are all sorts of rules, and usually disclosures are made when anyone uses a device within an institution, public or otherwise. If it weren't disclosed, I would certainly say that it's highly unethical and possibly illegal, but I think Ms. McPhail would be better positioned to answer that question on legal grounds.
With a few seconds left, if you'd care to answer, Ms. McPhail.
I think there's a number of different sort of interacting legal instruments that would be relevant in that situation, and they'd have to be examined carefully to really determine what kind of loopholes there might be.
Thank you. And now, Ms. Hefner for up to 6 minutes.
Thank you, Chair, and thank you to our witnesses for being here today and providing your testimony. Mr. Diebert, I want to go back to a little bit in your opening statement, and you've been talking about how governments use spyware to hack people's phones, and you mentioned that this has happened here in Canada. I'm wondering if you can get into a little bit more detail about the cases that you know of, what governments are involved in hacking, and what cases have we seen here in Canada?
Thank you for that question, certainly. So in 2018, we observed that Saudi Arabia was undertaking espionage, and we could observe based on our network monitoring that there was a hacked device in Quebec, and we ultimately discovered that the person whose device was hacked was a Canadian permanent resident named Omar Abdulaziz, who was a very close friend and confidant of Jamal Khashoggi. And we published our report on October 1st, 2018. The very next day, unfortunately, Jamal Khashoggi was apprehended and brutally executed in the Saudi embassy, the consulate in Turkey. We have also documented extensively other Canadian refugees, immigrants who have had their phones either targeted or hacked by foreign governments abroad as part of a growing number of cases that we call digital transnational repression. So the long and short of it here is that Canadians are definitely not immune to this worldwide risk that is growing in leaps and bounds, which is precisely why I think we need to be entering into this very serious conversation with a much more comprehensive approach than we have been to date.
Okay, well, I agree. It's a good conversation to have. So what do you mean by a more comprehensive approach? How can we protect ourselves against these international bad actors?
Well, first of all, as I said in my recommendations, I think we need to understand that we have an obligation to do more than just speak words about this topic. In fact, I wish we even spoke words about it, but really I've seen nothing coming out of the Ministry of Foreign Affairs or the Prime Minister equal to the level of statements coming out. Just to give one example, the United States and the Biden administration at the highest levels, the White House, Department of State, Department of Justice, have all made very powerful statements and have held inquiries and have started to penalize firms, recognizing the very serious gravity worldwide of this problem that's both a human rights issue and a national security issue. So I could reiterate my recommendations, but I think we need to begin with the fact that we have no export controls for Canadian firms that sell surveillance technologies abroad. That needs to change. We need to be more transparent about from whom we are procuring this technology. As you heard yesterday, the Minister of Public Safety wouldn't even acknowledge who they're buying this from. That there's no operational security reason why we shouldn't do that, and many good reasons why we should. Why? Because our procurement is a lever on the industry. If we're going to spend millions of dollars buying this technology, and it's very expensive, by the way, we can impose conditions on the firms and say, you know what, we're not going to buy from firms that have been widely associated with gross human rights violations, both abroad and here in Canada, unless they comply with certain standards.
So what we heard from the RCMP is that they would be releasing secrets to the criminal world if they were to release the technology that they use. And I don't know what their reasoning is behind that. But what we do know, or what the RCMP says, is that they've used this in specific targeted reasons for things like terrorism and murder and kidnapping and trafficking investigations. And it was with a lot of judicial oversight, many warrants required, specialized police departments get involved. So it's not, and this is since 2017. So what's your reaction to that, to what we know based on this study and what we've heard on the record and the use of the RCMP use of this technology to date?
Well, I would say that, security is a very serious thing, and we all need to protect ourselves from the threats that you're describing. Our law enforcement and intelligence agencies and our armed forces need to be properly modernized and equipped, and there needs to be judicial oversight over it. So it's reassuring that we heard that it was used for these type of cases and that there was a warrant for it. But just because there is a warrant, that we're being told there's a warrant, isn't a magic wand that makes everything else go away. And we should say, just don't look any further here. As I said, there's really no reason why you cannot disclose from which vendors you're purchasing this technology. We do not want to have taxpayer money going to some of these rogue mercenary companies that are contributing to human rights violations abroad and national security problems
Okay,
here in Canada.
Professor Dibert, we're significantly
Yep.
over time on this round, but it's good to try and get as complete an answer as we can, but we do have to move on. Oh, I'm sorry. This is a 6-minute round. My apologies. Sorry about that. Sorry, Lisa, and sorry, Professor. If you do want to add a little more to that, you may, and maybe squeeze in an extra question there, Ms. Hefner, if you'd like. My apologies.
But I guess what it comes down to is that there's no proof that the Canadian government has been using this spyware. It's all we have on the record here is that the RCMP has used it in certain circumstances to, under judicial oversight, to go after specific serious crimes.
Well, what I heard yesterday and in reading the news, I'm hearing something different. First of all, this revelation seemed to come kind of sideways. It wasn't really done in a forthright manner. I also heard that the Office of the Privacy Commissioner was not briefed on this. I also heard over the last couple of days, numbers changing. As you heard from my colleague, Ms. McPhail, there's a pattern of law enforcement in this country using investigative techniques and surveillance technologies and disclosing them after the fact. That's not the way you build public trust in law enforcement in a country. We are better than that.
Thank you. And with that, we will now go to Monsieur Villemeux.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I have a question for Mr. Deberg. If we look at the study to maintain trust of the population with the RCMP, as us yesterday, we have to basically believe what the RCMP tells us because we don't have any means to delve any deeper. So maybe to be able to teach the population, first of all, I'd like to ask, can we really trust when basically that's all we are told we can do?
My answer to that would be to invoke someone that you'll remember, and we're showing our age here, Ronald Reagan, who in response to Mikhail Gorbachev said, we need to trust but verify. And I think this applies to all of our security agencies. In a liberal democracy, it's essential that you have robust safeguards, oversight mechanisms, public accountability, and transparency. What we are seeing here is clearly failing that. And if you compare it to what's going on in other countries, it's not setting a very good example. It's in line with some of the flawed democracies around the world. So I think we need to have a much more robust net cast over all of this if we're going to use this type of technology, which, by the way, is like a quantum leap in capabilities. This is much different than a wiretap we're talking about here. A device provides a window into every aspect of a person's life and those around them. So as I said in my remarks, this is nuclear level surveillance technology. We need appropriate safeguards to match that sophistication and power.
Donc, vous ne serez pas d'accord avec...
Time, and I'm going to offer you the option to either continue with your round now, or we'll pause. You'll have 4 minutes and 10 seconds left, and we can go straight and get the opening remarks now from Mr. Juno.
I guess we'll get the remarks, I guess.
It's up to you.
No, please go ahead with the remarks.
All right, then I would like at this point to welcome our third witness. I'm glad that or at least I hope we've got all of our technical problems sorted out. I still don't. Okay, now I see your image. And welcome to committee, and I will permit you now to make your opening statements up to 5 minutes.
Thank you very much. Merci beaucoup, Monsieur le Président.
Thank you very much, Chairman. I'm sorry for the technical problems. Thank you, Mr. Chairman and members of the committee, for the invitation and the opportunity to speak to you on an important issue, one that gives rise to many other issues. At the outset, I would like to summarize my thoughts based on my experience in the service of this nation and in the private sector, which now totals over 40 years. This is part of my research work and the work that I've done in national security. What is being presented for your reflection is the appropriateness, the legality, the legitimacy, and the accountability of using a technology or technologies that can intercept conversations or obtain information that may be protected by the Privacy Act. Immediately, I would like to emphasize the importance of privacy as defined by the Charter and Canadian law. This protection is one of the central pieces of a healthy democracy, and without it, there is no democratic state possible. Having said that, I would like to put forward 3 points that are central to my testimony, and I'll come back to them. First of all, when it comes to criminal or national security investigation, with the adage that the end justify the means cannot be applied. Secondly, partisan jousting that has no place in such a debate, and it is the fruit of your collective work that will bring a better protection to our democracy and to our fellow citizens. And finally, having said that, this committee has a great moral and ethical responsibility to provide the legal framework and tools necessary so that men and women who are charged with protecting us can do so adequately and with respect for the foundations of our justice system.
One major trap for anybody responsible for collective safety is to believe that the end justified the mean. It is the most dangerous deception law enforcement officers are facing in the maze of bureaucracy and court system. Eager to accomplish their work of protecting us and waiting to stop criminal and terrorists ready to harm us, some officers might be tempted to go around the law. Our own Canadian history teach us the mistakes of the 60s and the 70s when the RCMP were put in charge of stopping communist agents or separatist zealots. In the name of protecting us, the RCMP officers broke the law, believing that they were doing the right things. They were misled and wrong. I listened and paid attention to the testimony given to you in the last days. I did not see or hear history repeating itself. I saw officers who, under pressure of not jeopardizing operational or tactical capabilities, answering, I believe, to the best of their ability, as much as possible, your question. Thanks to your important work, it is evident that we can enhance the approval process by improving consultation with the Privacy Commissioner, the reporting and evaluation mechanism, and the law itself. In addition, I was pleased to hear that the court system has kept in place the check and balances. That is good news and gives us hope that we are on a good track to improve our democracy system and accountability process. Mon deuxième point m'inquiète.
My second point is more worrisome because I have observed behaviors of some members of the committee that are of concern. Asking questions, even difficult questions, is the job and the responsibility of committee members. One guiding principle must prevail. You must protect and look after the interests of this nation and its citizens, and not the partisan interests of your political agenda. If you have questions that involve technical, tactical, or strategic capabilities, you must do in camera.
Public. Some of the bad guys, being criminal or foreign agents, are listening and taking notes. Asking questions, pushing to get, for example, the country of origin of a technology that must remain secret is to serve on a silver platter to the bad guys the means to counter the tactical capabilities. To continue making fake allegation of mass surveillance when there is no evidence that it is misleading and dividing our society. 39 cases, 41 devices spread over more than 5 years is not mass surveillance. Comme je l'indiquais,
as I said in my opening remarks, I have been observing and analyzing the threats to our society and our citizens for over 42 years. I have been one of those who have put their heart and soul into protecting our country and its people. I have experienced the frustrations and successes of our investigations and of efforts to prevent criminals, spies, and terrorists from harming us individually and collectively. I cannot describe to you with enough accuracy and thoroughness the waves of emotion that come over investigators when a bad guy wins because he has taken advantage of a flaw in our legal system.
Condensed.
Okay, so I will resume. Mr. Dufresne himself yesterday have stressed the importance of stressing the public interest or working on the public interest. In trust, the trust today is more crucial than ever for both our democratic system and our that you represent and the law enforcement and security agency that work hard for us. Je vous remercie de votre écoute.
I would like to thank you for listening, and I hope you won't, that you will hold my comments and warnings. It won't hold them against me.
Correct these trends, and to much the greater attention to the population is asking. Gentlemen and
thank
ladies,
you. I'm really going to have to let Monsieur Vermeulen resume his questions. You have 4 minutes and 10 seconds. Go ahead.
Too bad. It was good text.
I believe it, but time is precious.
Thank you, Mr. Chairman. I would like to ask you, with respect to trust, and I've come to my main point, with the RCMP, should we, what they've said, should that give us trust, or is it a question of, should it put them in doubt? Go ahead, this question is for you. Well, I think that the actions of the RCMP are important to be able to conserve public trust. The mechanism of accountability, consultation, judicial mechanisms that are in place are necessary to be able to ensure that we can improve this trust and conserve it. So I think that we've learned that there have been historic situations. Historically, we've learned from lessons from that. And what we were told yesterday, and also the different types of reflections suggested by Mr. Dufresne and other interveners are excellent to be able to help the committee make good recommendations. Thank you very much. Mr. de Burke, for the benefit of the population, can you describe exactly what spyware does? What can it do?
Mm-hmm. Thank you for that question, Mr. Chairman. So we have been studying many different types of spyware, and the most advanced allows persistent access to a target's device, which in turn allows them to do anything on that device and more that a user can do without the user knowing. Some of the latest versions of the spyware employ what's known as zero-click versions, meaning there's no need to trick a target into clicking on a link of a fake message. A user, a government client of spyware can simply issue a command and take over any device in the world that's vulnerable to this type of exploit. Once inside a device, you can intercept and listen to any phone call. You can read emails and text messages, even those that are encrypted. You could silently turn on the camera and microphone. You can review all of the contacts. You can alter files on the device. You can access a person's cloud account. You can track their location. So it is extraordinary, powerful surveillance technology. Keep in mind, we live in a different time than even 20 years ago, when a wiretap was something you'd put on a landline, or you'd place a bug in a suspect's car, or maybe a GPS tracker in their car. This gives you all of that and more, because these devices are designed by their manufacturers to be as invasive as possible. They're designed, as well as the apps contained in them, to track every aspect of our lives. So this is a gold mine of information that is available to clients of spyware.
Merci, Monsieur Debert. Je vais poursuivre.
Thank you, Mr. Debert. I'd like to continue with you. Yesterday, we were told that there were warrants and that a judge had to validate or authorize that this was good oversight. I don't know if you share my point of view. A situation may be legal, but it may not be ethical. And we've said that the legislation is 20 years old, and so there is a risk there. So even if we remain with legality, we can be unethical in our use.
Thank you, Mr. Chairman. Well, I think that the disclosure that there were warrants is certainly reassuring. I'm glad it's not the opposite case. However, I think that we need to put judicial oversight in the context of a number of different factors related to this environment, this topic that we're describing. First of all, I think there is a problem with transparency and public accountability within our law enforcement agencies. In fact, there's a pattern, as my colleague Ms. McPhail said, of not disclosing ahead of time certain investigative techniques that require a public consultation. Again and again, these are coming out through media revelations or in a kind of backhanded way. That's not the way to approach this topic.
Okay.
Secondly, there's
we're out of time for an answer. Maybe if you can sum up in a few seconds, then I'm going to have to go to Mr. Green.
Well, there are public safety issues with this very technology. There are equities involved because it involves exploiting flaws in software that make all of us insecure rather than disclosing them to the vendors.
Okay, thank you. And now Mr. Green for up to 6 minutes.
I would love to continue along that because I think it's important for the benefit of this committee that we get a better sense for just what this sector looks like. I know, Professor Diebert, you talked about it being rogue mercenary companies. Can you perhaps expand on, from your research, what this sector looks like, who's acting in it, where the subject matter expertise is coming from, and why we should be concerned about that?
So very little is known about this industry. It operates in the shadows by definition. It's similar to the trade in weapons technology or private intelligence. So these firms, generally speaking, don't like to publicly disclose what they're doing or who their clients are. That makes public accountability and transparency very difficult. We at the Citizen Lab, along with several other organizations, have spent well over 10, close to 15 years investigating this industry using a variety of technical methods and forensic methods. What we found is that there is almost no international regulation around this industry. They're selling to just any government client. Most of the governments, unfortunately, in the world are authoritarian or illiberal, and naturally, they're using this technology not in the ways that we're hoping for it to be used here. They're using it to go after political opposition, civil society, journalists, activists, and others. They're making millions of dollars doing so, and they obfuscate their corporate infrastructure from investigators like us. This is a very serious global human rights and national security issue. All you need to do is look at the reactions at the most senior levels of the United States government, the Biden White House, the Department of Justice, the Department of State, U.S. Commerce Department, have all come out and said effectively exactly what I'm saying to you right now. So we are really asleep at the wheel on the threats raised by the global mercenary spyware industry, and we need to urgently correct that.
So I know that there's been local reporting, and we've heard it here today in testimony from the government side, referencing a former Prime Minister, Stephen Harper, being involved. I think there's reports of a former ambassador to Israel also being involved, or at least reporting on being involved. Can you speak to the relationship between those within governments who've had perhaps some of the highest level of security clearance, then acting, and I think quite rightly you framed it as a mercenary sector? Can you talk about the dangers of people who have access to national top clearances then retiring into this sector, both from elected and civil agencies, but also from some of our highest law enforcement agencies as well?
Thank you for that question. This is a very serious concern because there is a well-documented revolving door. People who work for intelligence services then go off and make money, some of them very honorably, unfortunately, some of them not. I think it's shameful that a former prime minister would be involved in selling surveillance technologies, brokering Canadian firms' sales to Gulf clients that have a well-documented history of human rights abuses, which is why I said in my recommendations that we need to impose a lifetime ban for those who've worked for intelligence and law enforcement from ever working for mercenary spyware firms. We also need to have clear rules in this country on export controls over surveillance technologies. Citizen Lab has documented the export of censorship and surveillance technologies made by Canadian-based firms that have helped facilitate, frankly, violations of human rights abroad that would be unacceptable in this country. And I'm shocked to say that there really is zero licensing or export controls in this country for the export or sale of spyware and surveillance technology of the type that we're talking about to here.
Be clear so we can have you on the record, sir. Just to be clear, is that a recommendation that you're providing this committee, that we would recommend as a committee that these things be implemented, or is that just a comment?
No, 100%. It was in my testimony as a specific recommendation. We desperately need guidance to Canadian businesses, clear ground rules as to whom they can sell their technology so that we don't end up having Canadian firms supplying surveillance technology to regimes abroad like they have in the United Arab Emirates, Russia, Turkey, elsewhere around the world to help facilitate practices that would be clearly a violation of the charter in this country.
And there's still the concern that our government could do indirectly what it's not allowed to do directly by then taking advantage, perhaps, of information that might be unlawfully obtained by foreign actors. They could be friendly foreign actors. You know, you look at the use of Pegasus in places like Mexico, but Pegasus is just a brand. I mean, it's the technology that's out there that's pervasive. So could you comment perhaps on the possibility of having in the hands of government information that might be politically sensitive? We've seen this technology used against the media and against partisan opposition. So is that something you'd care to expand on and comment on in the final close here?
Mr. Chairman, I would say that many of the manufacturers of spyware have close relationships for geostrategic reasons to the governments within which they're located. And I don't have any confidence that information that is collected by those spyware governments or spyware companies on behalf of government clients ends up being passed on to specific individuals connected to their home government jurisdictions, which is why it's also a security risk that we need to have better due diligence around procurement. With due respect to one of my fellow panelists here, I don't see any operational security reason why we cannot disclose from whom we're purchasing this technology. Disclosing that, frankly, has no bearing or tips off no one. It's good practice. It's mature and a mature approach to a 21st century problem.
Thank you. And with that, we will go to Mr. Williams for up to 5 minutes.
Thank you very much, Mr. Chair. I'm going to stick to the professor as well, Mr. Debert. Thank you for being here today. In respect to the RCMP's use of this Pegasus-like cell phone hacking, this committee heard yesterday that these tools have been used since 2017, and not a single consultation has taken place with the Privacy Commissioner, and they had to hear about it in the news. And you understand well, as you've demonstrated, the implications this technology can have. Do you find the RCMP's decision to keep this information from Canadians acceptable?
No, I don't find it acceptable at all, Mr. Chairman. And I actually think that I heard something slightly differently from the testimony. It sounded to me like one of the RCMP officers testified that they were using this type of technology much further back than 2017, which really is no surprise. As Ms. McPhail testified a few moments ago, there's a pattern where law enforcement agencies are reluctant for whatever reason to disclose what type of surveillance techniques they're using or specific technologies, hide them from the public, and then somehow this information gets out through media or whatever, ATIP requests, and they have to scramble to produce documents to justify ex post facto how they're using it.
Do you think one of the recommendations I feel we're going to have from this study is that all government agencies, no matter who they are, should have to complete or be mandated to complete or lawfully complete a privacy impact assessment? Do you agree with that recommendation?
100%. It's the least that could be done, in my view.
Thank you. Ms. McPhail, your organization has called ODIT the nuclear option for surveillance for the RCMP. Why do you refer it as a nuclear option?
Thank you for that question. I think Professor Debert has referred to this, but I'll elaborate. We had yesterday an RCMP witness say, to paraphrase, we don't actually think about doing a privacy impact assessment just because we're using a new technology. We consider whether the technology permits a new kind of invasion, which sounds kind of logical until you break it down, because that formulation of the nature of the search ignores the reality of an ODIT, which allows all the invasions all at once on a device that we, not they, own. So did they do wiretaps before? Of course. Did those wiretaps allow access to the contents of every form of communication, written and oral, professional and private, retrospectively and prospectively, including data that's not actually on the device itself, but in the cloud? Of course not. Is it the same level of invasion? No. Did police install covert cameras in homes and places of business with warrants in the past? Of course. Did a single camera have the ability to move with an investigative subject from work to home, from bedroom to bathroom, 24 hours a day? Of course not. Is it the same level of invasion? No. And an audit can do more. It can record live audio. It can track location. It collects device identifiers. It tracks internet searches. It follows application use. So, I mean, should a PIA have been required? Of course. But even that, as Professor Diebert said, is not enough when we're talking about the enormity of the invasion.
Do you believe that the same recommendation, that no matter who they are, any government agency using new technology should be required to do a public or a privacy impact assessment?
Any government agency wishing to use potentially rights-infringing surveillance technology that carries high risk to the public should absolutely have to do a mandatory privacy impact assessment, which should be made in an appropriate form public.
Thank you. Mr. Juno Katsuya, in your work with government in the past or in your research, are any other agencies beside the RCMP using any similar technology that we're investigating with the RCMP?
You would have to be a little bit more specific, but some of the technology, of course,
CSE, anything like that. I guess the question is, do you have any knowledge that any other government agencies besides the RCMP would be using anything like this Pegasus-like technology?
Other agencies are using it, probably, yes.
Okay, thank you. Mr. Chair, I think I'm out of time.
You got about 15 seconds, so I don't know if you're going to.
I will cede my time. Thank you, sir.
That's what I like to hear. Keep us on schedule. With that, we'll go to Ms. Shanahan for up to 5 minutes.
I'm sorry, Chair. I'm not ready to ask any questions. I'm sorry.
I hope I didn't get the order wrong. Was there a different?
Yeah.
Ms. Vanderbilt? Okay, go ahead. Thank you.
Thank you.
Yes, thank you very much, Mr. Chair, and it's good to be back on this committee. The last time that I was on ethics, privacy, and information was the Cambridge Analytica Facebook study, and I found that we did some very good cross-partisan work on that issue. And this is, of course, an issue that concerns me very deeply. I'd like to direct my first question to Professor Diebert. As you know, and I think we're both on the World Movement for Democracy Steering Committee, I've long been an admirer of much of the work that Citizen Lab has been doing globally, both on disinformation, on cyber harassment of human rights activists. So I think you've raised some very concerning points with regard to how authoritarian regimes are using these kinds of tools. And I know that, some of the things in terms of what this committee is looking at specifically, some of the things that you mention, particularly when you're talking about the digital transnational repression and other things, might more suitably be discussed in the Foreign Affairs Committee or even the Subcommittee on International Human Rights on which I sit. And I think there'd be some significant interest in looking at that, including things like export controls. But my question to you is more specifically about, I think you'll agree that when the RCMP are using these tools and they're doing it in a very narrow scope, they're doing it, I think you mentioned things like proportionate, necessary, and they're using it with judicial oversight and warrants. That's a very different thing than somebody like China or Iran and how those regimes are using this kind of technology. So setting aside issues like the vendors and the export controls, you mentioned something that I think was interesting. You talked about having thresholds. If you could elaborate a little bit about what those kinds of thresholds to prevent abuse of these kinds of powers, what would those thresholds look like?
Thank you for that question. I think overall, it's reassuring that we heard testimony from the RCMP yesterday and from the minister that the instances of the use of this type of technology were undertaken with judicial authorization. However, as I said before, I think just because we hear from the RCMP that there was judicial authorization shouldn't be seen as like some kind of magic wand that makes everything else magically disappear, nothing to see here, go about your business. First of all, we know that there is a well-documented history of abuse within law enforcement in this country. There's a documented history of discriminatory practices. I also have concerns about the nature of the technology itself and whether, with all due respect to judges who I have confidence in, whether they truly understand the scope and scale and sophistication and power of the type of invasive technology that we're talking about that Ms. McPhail just really accurately described. I also think there are equities issues that need to be discussed here because you know, I routinely and my team routinely forensically analyzes victims of spyware. And several instances, we've actually recovered copies of the spyware and made responsible disclosures to the vendors, unlike what the government agencies do. These disclosures have resulted in security patches affecting more than several billions of people worldwide. If the government is going to withhold that information from the vendors and put all of our safety at risk, there needs to be a proper process around that. That process typically is called the vulnerabilities equities process. Right now, as I said in my testimony, our process around that in this country is weak. It's opaque. Frankly, it's nowhere near the level of where it should be for a mature liberal democracy. So those are some of the concerns that I have that go well beyond whether the RCMP simply told us that these instances were authorized by a judge.
Thank you. That's very helpful. Thank you. My next question is for Mr. Juno Katsuya. I noted in your opening remarks that you didn't finish your the part of your opening statement. I want to give you some time to do that now.
Hi, thank you very, very much. What I wanted to bring to our attention is that unfortunately, our society and particularly our democracy is under siege. We're facing enormous threat, like probably since the initial concept of democracy has started to appear in the 1600 and 1700. We've never been under a threat like we are currently. The far right, alternative right is taking place. Populist discourses, people using demagogy to try to convince people and to bring insecurity. So in that perspective, I totally support the idea of bringing more control, more accountability, more transparency. What I seek is a balance to not sort of prevent the capability to also catch the bad guys. Because unfortunately, all the nice discourses, theory, and philosophical debates, they don't care about this.
Okay, thank you. We went quite a bit over there, but we got it all out. So now for 2.5 minutes, Monsieur Villemure.
Merci, Monsieur le Président. Monsieur Dibert.
Thank you, Mr. Chair. Mr. Debert, I don't have much time, but are you in favor of having a third party that would examine the actions of the RCMP with respect to surveillance?
Yes, I'm in favor of as many legitimate parties as possible that are appropriate to make sure that we have proper accountability relative to the great leap forward in technological capabilities that law enforcement and security agencies have at their disposal today.
Merci beaucoup.
Thank you very much. Mr. Junot, you said at the end of your intervention that there are other agencies that are probably using this technology. Do you believe that the parliamentarians or elected officials have been surveilled? We have had to surveil parliamentarians because there are parliamentarians of all level, whether it's municipal, provincial, or federal, that are being paid by foreign governments and that are not necessarily acting in interests of Canada. So we do have people that are working, whether it's consciously or unconsciously, that they're threatening national security. Does a Pegasus type secure surveillance used, or was it beforehand? It was beforehand, and it's still happening. Foreign agencies try to recruit elected officials, and it's fairly easy because elected officials don't necessarily listen to the security guidelines to protect themselves, or sometimes they may be ignorant of it, or maybe serve their own self-interest. Well, thank you very much. Mr. Diebert, earlier you said that the privacy impact assessment was the minimum. So what would be ideal?
We need to have some kind of embedded presence of the Office of the Privacy Commissioner. I was frankly very disappointed to hear that the Office of the Privacy Commissioner was not informed about these investigative techniques prior to the recent revelations. So we need to have a much stronger presence, and I would argue even more capabilities and resources for privacy commissioners to act as a watchdog over our security agencies. That's not to minimize the very important mission that law enforcement and other security agencies have in this country. We want them to be well equipped, but we need to have organizations that watch the watchers. In part, that's the mission of the Citizen Lab too. We act as a public watchdog.
Professor Diebert, we are over time with that, and now to Mr. Green for 2.5 minutes.
Thank you. Ms. McPhail, you had mentioned that you recommended that there be a civilian counterpoint to police applications for warrants within the judicial process. Could you expand on that? Because that was something that I picked up as being a bit problematic in terms of how there's accountability throughout the warrants process.
Absolutely. And this echoes a recommendation that I made during the recent study around facial recognition technologies, which is that to counter this persistent pattern of police acquiring and using sophisticated and potentially controversial surveillance technologies without public disclosure, that we follow the lead of places like New York State, like New Zealand, in putting together an independent advisory panel that would include relevant stakeholders from the legal community, from government, from police and national security, from civil society, and of course our regulatory bodies who are relevant, like the Privacy Commissioner, to act as sort of a national standard-setting body, an advisory body, to take a proactive look at the kinds of technologies that our police forces want to use to modernize their investigative techniques, and look at them across a range of considerations that includes ethical considerations, legal considerations, around Canadian norms and values, and then make sort of standard-setting, gold standard recommendations that police organizations, not just nationally, but provincially and territorially, because of course policing is also a provincial and territorial matter, so that we would have consistency and the public could be assured that rights were being respected while police had the tools they need to do their difficult jobs.
Thank you. The use of the Pegasus tool is recognized by the Council of Europe as a violation of Article 8 on the right to privacy of the European Convention on Human Rights. Does the Canadian legal framework guarantee privacy protections similar to Article 8 of the European Convention, such as the use of the device investigation tools with technological capabilities similar to Pegasus could be considered perhaps unlawful?
I'm sorry, is that to me?
It was, yes.
I think that it's well known that Canada's privacy regime has fallen behind. I think that there have been many statements before this committee over the last almost decade documenting the ways in which our privacy laws, both public and private sector, fall short and fail and have gaps that fail to protect people.
Thank you, Ms. McPhail. We're over time, and now we go to Mr. Halan. Welcome to the Ethics Committee, and thank you for joining us today. You have the floor for 5 minutes.
Thank you, Mr. Chair. Thank you to the witnesses for being here. Mr. Juneau, I wanted to pick up on something that you answered from my colleague, Mr. Williams. I found it very interesting that you said other agencies are also using similar software as what Pegasus is. What other agencies are using these kind of software, and what are they doing with that?
Well, the agencies are the national security agencies. It's an investigative tools. They need to have it to be capable to pursue some targets, very dangerous, very serious people, and that is one of the tools that is accessible to them. Yes.
And what kind of software are they using? Is it the same software? Is it different for each agency?
I do not have all the details of what kind of software or the name of the software at this point, and I wouldn't be able to mention them. No.
But is it different software for other agencies? You don't have to name them, or is it the same software being used by other agencies?
I don't have the details about which one the RCMP is using, so I'm not capable to compare.
Okay, and in your opinion, is it just being used on Canadians, or are foreign nationals also, are they using the same software on foreign nationals?
To my knowledge, it's strictly on Canadians, but again, it's to be verified. I'm not aware of all the operational use that they made.
Now, the use of the software, in your opinion, is this always being done with a warrant, or some of this being done without warrants?
To my opinion, with a warrant.
Every single time?
Again, I have not audited all the agencies, so I'm not capable to sort of verify and certify that everything was done with a warrant. But the principles, if I take an organization like CSIS, no investigation is done without the due process of verification. And depending of which level of investigation is done, it might necessitate a warrant coming from a superior court.
Now, with this, with the approval for a warrant coming from a superior court, in your opinion, is this, have you seen that, is it one judge that's making a lot of the same decisions to grant that warrant? Or in your opinion, have you seen different judges?
The process, I've seen several judges in my experience, in my past. It's not all the time the same one, but certain have been selected due to the national security and secrecy level.
Okay, thank you. Mr. Diebert, after watching yesterday's, the committee, you've seen what witnesses were saying. I think one issue that everyone is talking about is trust right now, and how much it's been broken. You brought it up, and many other people are talking about it. After watching what the Minister of Public Safety had said, how do you think Canadians can even trust some of our institutions today?
Well, we definitely have a problem of trust with public institutions, and we're not alone in that respect. Globally speaking, there's, a decline around trust in public institutions. So we're not alone. But if we want to set a good example for the rest of the world and strive to be the best that we can be, I think it's pretty simple that we could do better than what we have seen in this latest case, which, as I've said before, follows a pattern in prior cases. We need to have, first of all, a very clear public consultation in line with the magnitude of the technology that we're talking about here, which represents a quantum leap forward in capabilities of surveillance. Without that public consultation and trying to approach this subject in the ways that they have in the past, keeping it from the public, not disclosing things that could easily be disclosed, I think we're setting a bad example.
I agree with you on that. Going back to you, Mr. Junot, you said politicians of all levels have been monitored. We don't need to name names, but can you give us a number of how many in your experience have been monitored?
No, I cannot give a definite number, considering the fact that in the concept of national security.
Is it in the 10s, in the 20s, is it in the hundreds? Can you give us something like that?
Again, it's difficult for me to mention the numbers because we work on a need to know basis. So if, for example, I have colleagues working on the Russian desk, they will not know if I'm working on the Chinese desk, some of the targets that I have. What we know for sure is that we have various foreign countries who succeeded in recruiting elected officials against municipal, provincial, or federal, and were capable to influence this way. We see that also when we see at the end of their mandate, cabinet ministers going to work for foreign companies that works directly against national security and national interests of Canada. So there's a certain concern when some people leave public office for what they've done, what they were during the public office, and what they do after public office.
Okay, thank you. Mr.
You are well over time, but that was
you, Mr.
quite
Chair.
an extraordinary answer. I'm going to, with that, go to Mr. Bazan. Oh, sorry, no, Ms. Khalid first, and that will, Ms. Khalid be the last one of the second round, then we'll go to the next. But anyway, go ahead, Ms. Khalid.
Thank you very much, Chair. I'll just start by saying, Professor Dibert, one of my staff actually attended a number of your lectures as a professor at U of T, and he had some really, really good things to say about your role and your expertise in this area. I really appreciate you being here today. Thank you very much. Personal connection. I just wanted to, I know the members have been asking questions that you don't really have the purview to answer because you don't have that direct information. And a lot of what we're discussing in this panel is really hypotheticals and what ifs and more of a policy perspective as opposed to a what happened evidence-based kind of perspective. So perhaps I'll put the question I'll start with Mr. Professor Dibert, if that's okay. About disinformation. And, we talk about the institutions that govern us and public trust. How does a concept that police, like the RCMP or police institutions, are monitoring and surveilling Canadians, what kind of impact does that have? I mean, to date, and we've heard from the RCMP, we've heard from the Privacy Commissioner with respect to exactly how many investigations have been conducted that have used audit surveillance. How does that impact public perception of the RCMP, of our governing institutions as in general, as we've seen kind of the climate of disinformation and conspiracy theories being peddled in recent events? Professor Dibert, if you have any comments on that.
Well, if I understand your question correctly, if you're implying that there is disinformation about some of the concerns that are being raised with respect to the risks and threats of this particular industry that's being that our agencies are actually contributing to financially, I think you're very wrong. We have done well over a decade of evidence-based research that has been cited widely using technical means. And we verified hundreds of individuals worldwide that are neither criminals or terrorists who've had their phones hacked using this type of spyware by governments, both authoritarian and democratic. In one of the most recent cases in Spain, we uncovered a massive surveillance espionage operation.
Sorry to interrupt there. We're talking specifically about Canada, right? The scope of the motion and the study that we have here is specifically about the RCMP. So we're talking specifically about Canada. If you could limit your answers to that, please.
Sure. Like I said before, it's reassuring some of the remarks that we heard in the testimony from the RCMP in terms of numbers and judicial authorization. I also heard, however, those numbers change in the course of a day. I heard that the Privacy Commissioner was not apprised of what's going on. I also heard that the RCMP itself, in direct response to a question, say, yes, we undertake surveillance of Canadians, which would be silly not to say because that's part of their job. The issue is precisely the lack of transparency and public accountability, because the way that we're entering into this conversation is kind of backwards, frankly. This was disclosed, it seems to me, almost by accident. And we shouldn't be having a conversation like this about this important topic in such a manner. That's not disinformation. What we're dealing with here is a very important question. We need to be mature about it and talk about it forthrightly rather than cast aspersions on people who are bringing up these important issues.
Thank you for that, Professor Dibert. Appreciate it. Monsieur Gino Cazio, if you have any comments on that.
Well, I like very much, like I mentioned, the necessity to exercise control, accountability, transparency as much as possible. It is part, and it's a cornerstone of our democracy. At the same time, we have responsibility to work against and to protect the Canadians against some very, very serious threat, which do not have any concern about the philosophical debate of what is right and what is not right. They do it, period. So I'm absolutely and totally in favor of this capability to find the right balance, to question ourselves, to work constructively in allowing the officers to be capable to perform their duty, yet at the same time making sure, just like I said, that the end cannot justify the means. We have to be capable to strike that balance in order to be capable to so. And that returns also to the responsibilities of the elected officials. Police are at the tail end of a problem. We're trying to sort of resolve something when we are facing the problem. But sometimes the problem, like terrorism, emerge for the lack of actions taken by politicians earlier when the grievance were brought to their attention. Not necessarily that you believe or you accept the grievance, but you must be capable to sort of take actions. And this is what the work of this committee is so important for.
Okay, thank you. That concludes that 5-minute spot. Now we're going to go to the third round in accordance with the formula adopted by committee. First will be Mr. Bazan for 5 minutes.
Thank you, Mr. Chair, and welcome our witnesses. Especially, I didn't have a chance to ask questions earlier to Mr. Juno Catio. Sir, it's just, again, I'm kind of dumbfounded with what you just testified, in that former politicians and politicians who are considered potential national security threats are being monitored. In your experience as a former CSIS and RCMP officer, in those situations, would jurisprudence be followed to ensure that their charter rights are protected by the issuing of warrants to wiretap or use spyware on those individuals?
To my knowledge, when a warrant was necessitated, yes, we used the warrant, and the judiciary process was followed. Very often, also, the politician or elected official, I like to say, were not necessarily the initial target, but they were actually came to the attention when we were watching foreign intelligence officers or foreign criminals or Canadian criminals being in contact with them. And it became a concern to either CSIS or the RCMP when these people demonstrated certain activities or certain actions that were questionable in light of their responsible office.
So, in these situations, like, should I, as an elected official who has been very outspoken in my support of Ukraine, Taiwan, and other democracies that are under threat, be concerned that I may be spied on by my by Canadian federal agencies because of my advocacy for those countries?
No, but you're likely to be concerned about foreign entities spying on you or wanted to use
I always
you,
am,
and
but
that's and that's why CSIS and the RCMP exist, to try to protect you because of these positions that you've taken. This is the sort of what we enjoy in our society, this capability of having outspoken elected officials that speak on behalf of our community, just like you do. But unfortunately, at the same time, you might become a target, and that's where we step in.
So, when we're looking at the overall use of technology, and I would say that it's probably changed quite dramatically since you were working for CSIS, how do we ensure that it is being used for the correct applications? You said in your opening statement that you don't want this committee to get into the details and undermine operational capability. But at the same time, as you've said, we need to have transparency, we need to have accountability, we need to know who is using this technology and how it's being applied. Where is the counterpoint in this where it tips that we're undermining the ability of our law enforcement agencies and national security agencies to protect Canadians?
I think some of the evidence that were presented, some of the testimonies that were presented, and Professor DeBert and others are on the right track to be capable to present certain entities that will be capable to do the check and balances, the verification, and ask for the accountability that is necessary. I think yesterday what I heard, maybe some people have heard differently, but I did hear the RCMP being open to this accountability. Maybe it didn't come soon enough, or the transparency didn't come soon enough in the opinion of certain. But this is what this democracy in progress is about. This is constantly sort of something that needs to be verified. And I'm absolutely, having been an officer in the front line, I'm absolutely in favor of this capability of accountability.
As an officer in the front line, can CSIS as an intelligence agency collect evidence that's not bound by the Canada Evidence Acts or the Criminal Code? So can CSIS deploy this type of spyware without a warrant?
No. CSIS will usually have to go through a warrant process in order to be capable to collect that kind of sensitive, and you use this kind of technology.
Only if it's a Canadian. If it's a non-Canadian, they wouldn't require to have a warrant?
No. If somebody would present a threat to national security, they can go against a foreigner. For example, there is diplomats who are not diplomats; they are foreign spies. We go after them.
Okay, thank you.
Be warranted to do that.
That's that's it. And now to Ms. Vandenbelt. Go ahead for up to 5 minutes.
Yes, thank you very much. I'd like to start my question actually for Ms. McPhail. And when I was in graduate school, I was actually on the board of the Alberta Civil Liberties Association. So, I applaud the good work that you do. When you gave your testimony, one of the things you said at the very end was that there are more problems, but there are also more solutions, and you didn't have time to be able to outline all of them. I think what this committee is very interested in are the solutions. So could you perhaps elaborate a little bit about what you see as some of the solutions and some of the ways in which the lawful, legitimate use of these kinds of technologies could be implemented without abuse and with proper accountability?
Thank you for that question. I think that there are a number of ways to proceed with legal reform across a range of different laws that would provide an improved baseline of accountability and transparency. Previous witnesses yesterday talked about making privacy impact assessments mandatory, and I do support that recommendation as a baseline requirement. But it was also mentioned, and I do support the idea of including in both our public and private sector privacy laws the existence of privacy as a fundamental human right, because that changes the nature of the balancing act that it's necessary to do when we're deciding whether businesses or governments are allowed to engage in invasive privacy practices. It puts the right at the center in a place where it should be in those balancing equations. It's also worth looking at Section 6, or Part 6 rather, of the Criminal Code, which to the best of my knowledge had its last very significant amendments slightly more than 20 years ago. It could be that experienced defense counsel in particular would be of great use to this committee in recommending alterations to that based on their experience with these kinds of contemporary technologies as their use emerges in criminal cases. And lastly, as one more concrete thing, the United States has created an entity list of banned spyware vendors. Canada should absolutely consider doing the same thing, which would provide some public assurance that our tax dollars are not going to support these dangerous and mercenary companies.
Appreciate that. Thank you very much for that. My next question is for Mr. Juno Katsuya. You mentioned in your testimony this need for balance, and certainly we are all very much in favor of transparency, but you even said in your testimony that even as we're here as a committee that is a committee holding to account, the bad actors are listening. I wonder if you could elaborate a little bit about how do you achieve that balance while not providing information that could strengthen those bad actors?
We have mechanism. Thank you very much for the question. I think we have mechanism to be capable sometimes in camera to be capable to receive and to ask difficult questions. The House of Commons has established a permanent committee now on security and intelligence, where they are capable to go across the board in every department and follow the trace and the track of certain cases. And that is extremely important. The challenge and the problem that we have is that they are elected members that are sitting on just like members of this committee. And every election, there's new members that comes with a new team, with a new group that doesn't necessarily have the experience or the knowledge or the network to be capable to dig in as much as they should be capable to dig in. Should we have more committee like the CERC, the Security and Intelligence Committee, that went from watchdog to become a lapdog with times, and they're not really sort of doing as much work as they should be sometimes to observe and criticize and bring some solutions to some of the problem. That's the problem, because sometimes the political systems interfere with the work of the committee and the independence. You've mentioned in one of your earlier comments that you enjoy the non-partisan element of the committee and the work that has been done. That's what should be sought as much as possible, because at the end of the day, we should be working for this nation, not working for our either partisan interests.
I agree 100%. How much
You're
time
down
do
to
I
20 seconds, so
okay. Thank you very much for that.
Whatever you're going to do, make it quick.
If I may add one element, we're spending a lot of time talking about the law enforcement, which is the leitmotif of this discussion. But one area that has been neglected is the private world. The private world, private companies are using this kind of technology far greater and far more than the law enforcement, who are much more surveillance.
Thank you, and we can only deal with so much within the constraints of a single short study, but indeed we've heard repeatedly over and over and over again of the need for modernization of the Privacy Act, which would apply to private interests and corporations. So now to Monsieur Villemeux pour 2 minutes et demie.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. Ms. McPhail, in your view, when law enforcement uses this type of spyware, do you think that contradicts or flouts the Canadian Charter of Rights and Freedoms?
Thank you. From what we've been told, in the way that these tools have been used, the RCMP has attempted to stay within the confines of the Charter by ensuring that they get judicial authorization, by using these for a small number of investigations, and ensuring that it's only for crimes that are ostensibly particularly serious.
Merci.
The issue.
Thank you. I have very limited time, so I have to make this quick. Mr. Diebert, you mentioned that Canada is chairing the Freedom Online Coalition this year. Do you think that Canada has the responsibility of setting the example in this sense?
Yes, I do.
Et quelle serait votre première...
What would be your first suggestions to this end?
Like I said, I think that we need to have from senior officials, from the Prime Minister, from the Minister of Public Safety, from the Minister of Foreign Affairs, clear, forceful statements that this industry that we're touching on in this committee is a threat to human rights and democracy and to our own national security, that we are going to take measures aligned with our allies in the United States and Europe and elsewhere to start holding the worst actors in this industry more accountable and be more transparent and publicly accountable ourselves if we're going to use it domestically.
Donc, on commence par le ton.
So we're starting by setting the tone at the top.
Which we have not done, unfortunately, in contrast to the United States.
Absolument. Merci beaucoup.
Yes, thank you, Mr. Junakatsuya. I have very limited time, but I was disturbed by the revelations that elected officials could be recruited by foreigners. Do you have a document that you can provide to the committee which can dig deeper a bit into this sort of issue? I do not have official documents, but there might be, I might come up with analysis based on my experience over the years, but to be able to obtain more detailed information, you would need to go to the entities in question. For instance, CSIS, the former head of CSIS, for instance, already mentioned in an interview that there have been elected officials at different levels that have been compromised. So I think the agencies themselves would have more information on that. Thank you.
Mr. Green for 2.5 minutes.
Thank you very much. Ms. McPhail, you'd mentioned Section 6 and the fact that it had been 20 years since it's been revisited, and I think both you and Professor Diebert have talked at length about the ways and the order and magnitude in which technology has far surpassed legislative guardrails or considerations. Section 6 was cited at length and very frequently by both the minister responsible and the witnesses from the RCMP. Can you comment from your perspective and opinion ways in which you think under the current legislation, the current laws of Section 6, there remains a big gap in terms of where we are now with these types of technological powers?
Part 6 of the Criminal Code, and I remind the committee I'm not a lawyer, although I work for a legal advocacy organization, is generally written to be technologically neutral and to allow for the right kinds of inquiries to be made with the right safeguards. But because the technology has changed so fundamentally, my point was simply that those who are expert in the use of this part should be ideally allowed to comment on the ways in which it should be enhanced. I'm not the best person to comment on it. I simply wish to flag that was a really important consideration.
Yeah, and is it a consideration that you would put as a recommendation from this committee that we recommend the government review Part 6 to ensure that it's in keeping with the advances in technology?
Yes, that is my recommendation.
And Professor Diebert, is that one that you share as well?
That's correct.
And I'll put the question to our last witness, and I apologize if your name has escaped me. Is that something that you would agree that Part 6 perhaps hasn't necessarily kept pace with technology and could, for the good and welfare of democracy and everything that you've espoused in your testimony, provide that updated information and legal analysis?
It's a must.
Oh, okay. Thank you.
Thank you. And with that, we move to Mr. Williams for up to 5 minutes.
Thank you very much, and through you, Mr. Chair. Both to Professor Diebold and Ms. McPhail, municipal and provincial police are not subject to the Privacy Act. Is that correct?
Yes.
And I guess what I'd ask for both of you for recommendations to this committee, what parts of the criminal code should we be amending or making recommendations to deal with these new techniques at this time?
As we just discussed, Part 6 of the Criminal Code is the relevant section on electronic surveillance that requires a review.
Okay. And sorry, I meant to say regarding also provincial and municipal police forces and their use of this technology.
Because policing is a provincial and territorial responsibility, there is actually a patchwork of different pieces of legislation that are relevant. That's part of an overarching problem in terms of assuring that all police forces across the country adhere to golden best standards when it comes to uses of surveillance technologies, which is why rather than doing a patchwork approach of encouraging provinces to amend a series of pieces of legislation in each of their jurisdictions, I recommend that there should be a federal advisory body to produce advisory bulletins that those provinces can then take forward and attempt to implement within their own jurisdictions to achieve consistency and best practices across the country.
Okay, thank you. And Professor, anything to add to that?
Yeah, I would just like to add, I'm not a lawyer, but one thing I have observed from my research globally is that the spyware industry has a very strong appetite to sell to local law enforcement, where the abuses tend to be more problematic. Of course, they want to do this because it opens up new prospective clients. And so I have great concern beyond the RCMP that there may be other agencies that have used these investigative techniques and we not yet found out about them.
Okay. Mr. Juno Katsaya, so you've talked about this use of the current technology we're talking about today being used in other government departments. I'm going to ask you specifically, do you know of other technologies? I mean, this technology we're talking about today was developed a decade ago. Are there new technologies? I understand you haven't been around some agencies for a little while, but do you know of any other technologies being used that this committee is not talking about today?
You would need to be a little bit more precise for what purposes.
Well, I'll keep to the same theme, surveillance. So, you know, I might be talking about drone or, you know, satellite. Is there other technologies that we're not speaking about today that you know that are in existence?
Aerial surveillance from satellite or coming now with the drones or coming from an airplane has been used for decades. What we do is we keep up as much as possible with the technology. So drones now have been used by other departments, and particularly national defense when it comes to military theaters. There is other form of surveillance that are done as well to track vehicles, to track individuals, other than with their cellular phone. So yes, there's a multitude of technology that have been used, which have the aim of being capable to mitigate the threat that are coming from the serious people we are tracking.
And do some of those technologies, do you believe they're being also used by RCMP? Would this be different government departments or to one or two?
When we talk about the surveillance element also, what is important is that not all surveillance equipment acquires information. Not all information is collected. Sometimes it's just to tag, quote unquote, a person or a vehicle or an object to be capable to follow that device that we are tagging. So yes, other departments are using also surveillance techniques and surveillance technology.
Okay, and in terms of what we've talked about today, just to get your general perspective, do you believe that we should be looking at privacy tools or making sure we're doing privacy impact assessments? Do you believe that in terms of technologies that come out? Is there a role for the Privacy Commissioner?
Yes, there is a role for that.
Okay, thank you.
Okay, you're just about out of time. So
well, close enough.
I'm going to go then to Ms. Hepner for the final 5-minute round. Go ahead, Ms. Hepner.
Thank you, Chair. Mr. Juno Katsuya, I'd like to go back to you. We have been, you sort of touched on your impression that revealing the source of the RCMP spyware technology could render that technology unusable to the RCMP. Can you explain that in more detail to this committee, why that might be?
Well, contrary to Professor DeBert, I do believe, because we've done that ourselves, when we are capable to identify the technology that a foreign government or our target is using, we are capable to either use countermeasure or to exploit that technology. So the knowledge, it becomes intelligence. It becomes important now to know what the opponent is using in order to, like I said, to counter or to exploit it. That's why revealing it openly, and this kind of technology, it's not a myriad of company. There's a great number, there's a good number, but there's not a myriad of numbers. So by isolating the country where it's coming from and stuff like that, by deduction, you're capable to be identified what the RCMP is using or any security agency, and therefore being capable to maybe mitigate their capability, tactical capability.
And why do you think it's dangerous that in some points in this committee, we've delved into accusations of mass surveillance or that, unfounded suggestions of mass surveillance keep coming up. Why is that dangerous coming from this committee, do you think?
For two reasons. First of all, there's no evidence that there is mass. The other element as well is the cost. One way to evaluate how plausible that the technology has been deployed is to go with the cost analysis. Just one operation will easily reach the $500,000 just to do one interception, one target, maybe one device only. It takes a lot of time, a lot of resources to be capable to install the information, install the software, to monitor the software, to debrief the software, to sometimes translate the language or the information that has been there. So when you add up at the end of the day, there is a simple calculation of budget at the end of the day that we're not capable to deploy that abundantly because it's too expensive. So to turn into what Mr. Snowden has revealed with the NSA capability, it's like talking apple and oranges. The NSA has budgets and capability and intentions that are way different than what the RCMP and CSIS or the NDA is capable to deploy here in Canada.
Thank you very much. And that's sort of a perfect segue, Chair. With the last couple of minutes of my time, I would like to move a motion because of that very reason. I think we have had a bit too much innuendo and accusations about mass surveillance in this committee, and even outlandish comparisons of the RCMP to the German Stasi. And I think that as a committee, we should come together and show support for the important work that the RCMP does do while ensuring their accountability under the Charter of Rights and Freedoms. So I will read my motion and we will circulate it to members of the committee in both languages as well. The motion reads that the committee affirm that it is satisfied that the RCMP is not using Pegasus or NCO group technology, that the use of audits is reserved for only the most serious cases, that the approval of a request to use audits comes with strict terms and conditions and must be ultimately approved by a superior court judge, that the use of these tools without judicial authorization would be a criminal offense, that the committee affirmed that it is satisfied that the RCMP is not using Pegasus or NCO group technology, that the use of audits is reserved for only the most I'm repeating myself here a bit. The final line is that the committee supports the RCMP in their mandate to protect Canadians from terrorism, human and drug trafficking, money laundering, and murder while ensuring accountability. So I apologize, in my copy here, I have it repeated, but we'll send the proper copy to all members of committee. And I look forward to any questions that my colleagues might have.
Huh? You just adjourn the meeting. You don't have to adjourn the debate. No.
Before we debate the motion, the clerk is just going to read the motion. I understand that, has it been received electronically?
Everybody should have.
Okay, all right. Okay, just.
Speakers list, yeah?
Do I? No, I'm not quite there yet. All right, thank you. Okay, thank you, Ms. Hefner. The motion is in order, and I did have Mr. Green, and I also see Ms. Khalid next, so that's who I have for speakers so far. Go ahead, Mr. Green.
Thank you very much, Mr. Chair. I move to adjourn the meeting.
Point of order, Chair.
I can't entertain a point of order.
I had my hand raised before, right when Ms. Hefner was reading the motion. So I don't believe that anybody had raised their hand before I had.
I recognize Mr. Green, and I can do my best to see who wishes to speak. Mr. Green was also trying to get my attention, and I can't. In fact, I'm not going to even rule on that point of order since we already had a motion to adjourn.
Sorry, Mr. Chair.
With a motion.
I would like a ruling on that point of order because I feel that this is very unfair.
He just did.
I know that in the room I have been called out for not being there in person and by members who have not shown up in person themselves for 75% of the meetings themselves. I would appreciate, Mr. Chair, if you could be a little bit more fair and more judicious in how we conduct our meetings.
Then we'll proceed to proceed. I'll have the clerk may proceed then.
So the question is on that the committee do now adjourn. Mr. Green.
Yes.
Mr. Bazan.
Yes.
Mr. Halan.
Yes.
Mr. Williams.
Yes.
Monsieur Villemeur.
Oui.
Yes.
Ms. Khalid.
I vote against. Love to see how the law and order party is running away from this
Mr.
motion.
Dhaliwal. He's trying. Good afternoon, Mr. Dhaliwal. The question is on shall the committee that the committee adjourn?
Yes.
Yea or nay? Welcome. Ms. Vandenbeld.
No.
Ms. Hefner.
Nay.
Ms. Shanahan.
Nay.
And I'll come back to Mr. Dhaliwal.
Eh?
Nay. So we have 5 nays, 5 yeas.
Right, and I vote in favor of the motion to adjourn. Meeting is adjourned.